Good evening. My name is LaDonna Lusher, and I'm a partner at Virginia and Ambinder. We're a law firm in New York City that represents workers that have been discriminated against, underpaid, and sexually harassed. My firm has counseled numerous employees that have suffered egregious forms of sexual harassment by their supervisor or their boss, as well as from coworkers. We've counseled employees that have been shown pornographic pictures, that have had cell phones stuck under bathroom stalls where photos were taken of them in their privacy, individuals that have been groped and grabbed, and individuals that have been intimidated into having sex with their superiors. And while we've spoken with employees that in all types of industries that have experienced this harassment, I'm going to focus on tech and employees in the tech and finance industries tonight, because we've counseled employees in those areas recently, and I thought that that's an area that I could speak to the commission on. One of the things that my firm has noticed in counseling these employees is that a lot of times they're given assignments on a temporary basis before they become permanent employees, which makes them particularly vulnerable to harassment. There are savvy harassers that will target these employees because they know that they're dependent on getting favorable reviews before they get permanent offers of employment. One such employee that we counseled worked for a prominent bank as a business analyst, and she was assigned to a supervisor who consistently harassed her throughout her employment. He used her status as a temporary employee to take advantage of her. First, he started out demanding that she accompany him to lunches and dinners, then telling her later that he needed more from her in order to renew her contract. He would grab her breasts, her buttocks when she was alone in her cubicle. He consistently made degrading comments to her about her wardrobe and about the appearance of other women in the office, and he eventually demanded she have sex with him. She gave in to his advances eventually and tolerated this abuse for years because she was fearful that she would lose her job. While this employee finally decided to complain to other superiors at the bank, they dismissed her comments and simply responded that they knew that he acted inappropriately sometimes. This leads to another issue that I believe that temporary employees face, and that's that their complaints are often not taken as seriously as permanent employees. Companies know that they can terminate the contract of these employees and think that they won't be coming back to work there. Alternatively, sometimes a company's response is to transfer the supervisor to another department, thinking that this individual isn't going to prey on other employees. That's where I would echo the testimony of other individuals here that talk about mandatory training, that could go a long way, particularly when companies think and use as a defense often in litigation that this person, well, we've moved him to a different department. Another area of concern for many tech and finance employees is that they have temporary authorization to work in the United States. And they're again fearful that if they were to complain that authorization may get revoked or they won't get their employment renewed. So again, I would echo testimony that you've already heard tonight, that the statute of limitations should be increased for these employees to make complaints. And for all employees, it takes a lot of courage for employees to get up and decide to complain, and it may take them longer than a year to be able to get that courage. And temporary employees can often get a permanent job status later on, that then they may feel more secure in their employment, and that a longer statute of limitations may allow them to then file a complaint. Finally, I will just address another area that was raised briefly, but that's arbitration agreements. More and more, as my firm counsels employees, we see arbitration agreements just pervading workspaces. And arbitration is important to realize in the sexual harassment context, because part of the whole hashtag #MeToo is that everyone's getting out and telling their stories, and it's bringing these issues to light. And obviously the commission is meeting tonight because there have been so many stories in the news lately. When someone is forced to go to private arbitration, their claims are heard by a mediator, and they're not heard in public in open court. And there are often rules that they can't speak about what happens, particularly if a settlement is reached. By having mandatory arbitration, this prevents these stories from being heard, and then harassers know that the company has just paid off the employee and that they aren't subject to any kind of retaliation, basically. The thing that we would suggest as far as the mandatory arbitration agreements is that the city could refuse to do work with contractors who have mandatory arbitration agreements for their employees. Or they could also make it mandatory that sexual harassment complaints are exempt from arbitration so that these employees could then file their claims in court and that these issues could be addressed on a more public basis. These are the suggestions that we have. Again, I'd like to thank the Commission for this. I want to say on a personal note that my firm appreciates the work that the Commission does, and that when a client comes into our office that has performed work in New York City and when they have some type of claim, we know that New York City has the strongest, most liberal laws in the country, and we can evaluate that claim on a different level than we can from someone else that comes in from another area of the country, and we appreciate the work that you do. Thank you.